Good afternoon, everyone. My name is Mary Bauman. I'm with Miller Johnson, and you are called in to our webinar, New Regulations to Help Employers Ease into ACA's Pay-or-Play Penalty. On the call today, I'm joined by Associate Attorney Tripp Vander from Miller Johnson, and the two of us are very glad that you've made the time out of your day to call in, and we hope that this information will be helpful to you. Just a few housekeeping matters before we get started today. We first wanted to let all of you know that we're recording this webinar, and so if, for example, you want to listen to it again, I don't know if you're necessarily going to want to do that, but if you do, or maybe you have a colleague that you know wanted to attend and couldn't do so, please look out for an email that we'll be sending after the webinar giving you a link to our website so you can listen again to that recording. In addition, also look for that same email that you're going to be receiving after today's presentation that's going to give you a copy of the slides. As we go through them today, you'll be able to access a PDF copy of the PowerPoint. So that's also for your information. And finally, as you can imagine, the regulations that we're going to be talking about today were 227 pages long, and we've got a lot of ground to cover, and because of that, we're really not going to be taking questions during the presentation today or immediately after the presentation. As always, you can feel free to contact Tripp or myself if you have follow-up questions specific to your organization when we're done. Or, of course, you can contact any other attorney in our employee benefits practice group that you regularly work with. So with that, let's get going on today's presentation. So the focus of what we're going to talk about today is the final regulations. And the final regulations were issued on Pay-or-Play earlier this month. They modified some regulations that were issued more than a year ago and also some subsequent IRS guidance. Now, before we really get into the meat of the regulations, we think it would be helpful to just take a step back and look at the pay-or-play so we're all coming to this from the same starting point. As you may recall, the pay-or-play penalty applies to large employers with at least 50 full-time employees and full-time employee equivalents during the previous calendar year. You usually make that determination by looking back at the entire preceding year, but for the first year, for making this determination for the first year, this can be on a shorter basis, only considering 6 consecutive months in the prior calendar year, and the IRS views that as more helpful in this initial year to help those employers get ready, particularly in the event they think they're a large employer. Now, as you all know, the pay-or-play was originally set to take effect as of January 1, 2014. But in the cloak of darkness on the IRS website, right before the July 4 holiday, they announced that they were pushing back the effective date until January 1, 2015. So a one-year reprieve, and as all of you know on the call, while this was a reprieve in this particular aspect of healthcare reform, all other aspects of healthcare reform were full steam ahead and did not enjoy that same delay in the effective date. Now, there are 2 different penalties under the pay-or-play. The first is the $2,000 penalty, and the second is the $3,000 penalty. First, let's touch on that $2,000 penalty. If you are a large employer, 50 or more full-time employees, full-time employee equivalents, and you don't offer a health plan to at least 95% of your full-time employees and their dependent children, at least one of your employees who is low income and full-time goes to an exchange, receives a premium credit, in that event, you have to pay an annual penalty of $2,000, and here's where it hurts, multiplied by all of your full-time employees, disregarding the first 30. Now, you notice that I mentioned there you have to offer coverage to full-time employees and their dependent children, not their spouses. You don't have to do that if you don't want to, but you do have to provide coverage to dependent children. And Tripp, I know that when the new final regulations were just issued, they provided us with some clarification as to what that exactly means. And can you comment on that?
Sure can, Mary. As you can see on our slide, while the definition of dependent children includes natural-born children and adopted children, the final regulations clarified that the definition of dependent children does not include stepchildren or foster children. I think maybe the more important clarification that we also got is that to offer coverage dependent children requires that you offer it to them until the end of the month in which they attain age 26. The reason that is important is we are aware of a lot of employers who only offer coverage until the child's 26th birthday.
And Tripp, wasn't that permissible under the original market reform that came out a couple years ago?
You are correct, Mary. You only had to offer coverage up until the child's 26th birthday. So this is a new requirement. The good news is we have some transition relief. So as you can see on the slide, as long as employers are taking steps in 2015 to offer coverage to dependent children, there will be no penalty. So it appears that as long as for those employers that only offer dependent coverage or dependent children coverage, up until the child's 26th birthday, as long as they in 2015 start taking steps to offer that through that entire month in 2016, no penalty will apply.
So that's good news. And I think for some of you on the call, you may have heard me previously say, boy, I'm concerned you may have to add coverage for foster kiddos next year or now 2016. The regs definitely clarified that as well. And so, Tripp, any other category of dependent child, like legal guardianship, grandchildren, don't have to cover those either, right?
That is correct.
You'll notice I'm asking Tripp a lot of questions so he can be nice to me and say, thank you, that's correct, Mary. So we don't normally get along this well, but we're going to do so for today's session. Okay, the second penalty is the $3,000 penalty, and this one does not apply in the same manner as the $2,000 penalty. So if an employer does offer coverage to at least 95% of its full-timers, but the coverage that is offered is not affordable or it's not of minimum value, and just one low-income full-time employee receives the credit, the employer has to pay the $3,000 penalty. But unlike the $2,000 penalty, it's only for each such full-time employee, not on the entire group. And this penalty also, by the way, is capped at the maximum amount the employer would have to pay under the $2,000 penalty. So what does affordable mean for this purpose? It really means that what the employee's required contribution is for single employee coverage under the employer's least expensive medical option. So if the employer offers 3 medical benefit options, we're looking at the cheapest one, the single employee coverage tier only, and we're looking at whether it exceeds 9.5% of the employee's pay. Now, the proposed regulations issued more than a year ago gave us 3 safe harbor ways to get our arms around that. One would be to compare the annual premium to the employee's Box 1 W-2 wages for that year, so you wouldn't find out about that until January of the following year. Another safe harbor was the rate of pay safe harbor, where we basically looked at the person's rate of pay at the beginning of the plan year, and for every month we converted that to a monthly figure. If they were an hourly worker, you'd look at their hourly rate of pay multiplied by 130 to express a monthly amount, and then you compare that with the monthly premium. And then the final rate safe harbor affordability test was based upon the federal poverty line for a single person, so a single household, and what that would be. And so, for example, for 2014, I believe the federal poverty line would translate into a 9.5% figure of a permissible employee contribution of a little over $92 a month. So that's just the example for that particular option. Tripp, did the final regulations that were just issued change any of these safe harbors?
They did not change any of the safe harbors, but they did provide some additional clarification on the rate of pay safe harbor and the federal poverty line safe harbor. So previously, under the proposed regulations, using the rate of pay for hourly employees, you were really locked into that rate of pay for the entire year. So if you reduced an employee's hourly rate of pay, the rate of pay safe harbor was no longer an available option for you. The final regulations did clarify and I guess changed that a little bit and said if an hourly employee's rate of pay is reduced throughout the year, the rate of pay safe harbor is still available, except you're going to look at it on a month-to-month basis rather than just taking a snapshot of that rate of pay at the beginning of the year. With respect to the federal poverty line safe harbor, the final regulations clarified that you can use the federal poverty guidelines that are in effect as of the beginning of the plan year, or the ones that are in effect all the way up to 6 months before the plan year. So that actually provides a little bit more planning opportunity if you're going to use the federal poverty line safe harbor and where you're going to set those affordability rates, because you have that additional 6 months to make those calculations.
So in other words, they change the federal poverty line every year.
Correct.
And of course, you can see on this slide, one thing that we get asked about a lot is, okay, Mary, so the affordability test is based on the single coverage tier, but what about dependent coverage? Currently, the rule is the cost of dependent coverage is disregarded under the affordability test. So you could charge for dependent coverage as much as you want. Question we get a lot is, will that ever change? And the answer is, it doesn't appear that that's permitted or contemplated by the initial legislation. So if that was to change, we think it might very well take an act of Congress. And I don't know about you, Tripp, but I think that might be unlikely.
I agree with that.
And the minimum value test is really focusing on the person's out-of-pocket costs, deductibles, co-pays, co-insurance, et cetera. And it's really looking at whether the plan pays at least 60% of the total allowed cost of benefits under the plan. Any option on one of the exchanges will be minimum value, and the average employer group health plan, even a high deductible health plan, is going to satisfy that test. Now, we want to turn, so that's the pay or play. We now want to turn to the transition relief that's under the final regulations. And here, there are definitely some differences, and I apologize for all the detail on this slide, but we thought it would be helpful if we had this whole thing all together so you could see it and have it all in one place. So mid-sized employers, you may have heard about some of this in the news media. So if I am an employer that I would ordinarily be a large employer because I'm at 50, or I'm at 50 and I'm all the way up to 99 full-time employees and full-time employee equivalents in 2014, I can qualify for a 1-year reprieve from the pay or play. So I'm not worried about this whole thing until 2016, but I have to satisfy some requirements. One, I can't reduce my workforce just simply to qualify for this exception. So you don't want to lay off a bunch of people right now and say, oh, I was at 105 and now I'm at 97. The other thing you can't do is you can't look at your plan now and say, you know what, I'm going to make a bunch of cutbacks in my plan. I can't eliminate coverage. I can't materially reduce coverage if I offer health coverage right now and qualify for this transition relief. And then the final requirement is a certification requirement. Tripp, what's that about?
Supposedly the IRS will prepare a form in which you're going to certify that, one, you are between 50 and 99 full-time employees. Two, you haven't reduced your workforce during that period. Three, you didn't materially reduce or eliminate any health coverage. However, not surprisingly, that form has not been prepared or distributed yet. So that's something we have to wait for.
Something we have to wait for. Okay. So let's say you're not a small employer, you're not a mid-sized employer, but you're a large employer. You're a large, and when I say large employer, I mean, you know, over 100 or more. What's up with you? Well, you're going to be subject to the pay or play in 2015, but there were two important transition rules for the first year that were added by the final regulations. One is, remember how I just got done saying to avoid the $2,000 penalty, you have to provide coverage to at least 95% of your full-time employees. Just for the first year, you will not be subject to the $2,000 penalty as long as you offer coverage to at least 70% of your full-time employees. So this is intended to give you a little bit of a glide path toward compliance. And also for the first year, if you were subject to the $2,000 penalty, you can disregard not just the first 30 full-timers when calculating the penalty, but really the first 80, and that is in recognition of the transition relief for mid-sized employers to put you on the same footing as a mid-sized employer in that regard. Now, the next transition rule is something that was provided under the proposed regulations, but has been tweaked in the final regulations just issued. And this is a little complicated, so hang in there with me. But the whole point of this transition rule is for non-calendar year plans. So if you're a calendar year plan, you know, you can go get your cup of coffee right now when we go over this rule. The final regulations say that if you are a non-calendar year plan, you will not have to comply with the pay or play as of January 1, 2015, but rather you have till the first day of the 2015 plan year. Now, one of the questions I get a lot of times is, well, Mary, what's plan year mean? And unfortunately, there is no precise definition, but it would appear that it means the cycle on which employees elect their benefits for the year. And the reason I say that is because one of the rationales in providing this relief given by the IRS is so employees won't be required to have mid-year election opportunities given to them. So that appears to be the definition of plan year. Now, in order to qualify, there are 3 different rules. 2 are old, 1 is new. And in order to qualify under each one of them, the plan had to have been in existence on a non-calendar year basis on the magical date of December 27, 2012, and it can't have been amended to move that start of the plan year to a later date in the calendar year. So, Tripp, does this mean that some plans simply won't qualify?
Absolutely. December 27, 2012 was the date that the proposed regulations were released in pre-publication form. But the types of plans that wouldn't qualify is any new plan that was created after this date on a non-calendar year basis. There's another question that I think is unclear at this point, which are calendar year plans that existed before or after this date, but were merged into non-calendar year plans that existed before this date. Will the employees that are covered under these previous calendar year plans qualify for this transition relief? And I think at this point that's pretty much unclear.
I agree. I agree. Okay, so let's look at the 3 transition rules. Transition rule number 1 is with respect to any employees either eligible for or actually enrolled in your non-calendar year plan under its terms as in effect on February 9 of this month, the penalty will not apply until the first day of the employer's 2015 plan year. You might think to yourself, oh, well, that's all I need. I'm good to go, right? Well, think about that for a second. What if you don't offer group health coverage to all of your employees working at least 30 hours a week? Maybe your current definition of full-time is somebody working 34 hours a week. Well, then transition rule number 1 isn't going to apply to the employees in the 30 to 34 hour a week range. So here's another transition rule that can help you with respect to those employees. If, as of basically any date in the past year, you actually covered at least a quarter of all of your employees under your non-calendar year group health plan, or as of the most recent open enrollment period that ended before this month, at least 1/3 of all of your employees were actually offered coverage, then you would qualify under this second transition rule. Now, there's a 3rd transition rule, and this is new. This was added by the final regs, and what it says is if you can't satisfy rule number 2, an alternative is you also satisfy the transition rules for all your full-time employees, including those working 30 or more hours a week, as long as you actually covered at least 1/3 of all of your full-timers in your group health plan, or as in some date in the past year, or at least 1/2 of them were actually offered coverage during the most recent open enrollment period that ended before this month. Tripp, why did they add this 3rd transition rule?
This 3rd transition rule was really directed towards employers that have a large number, part-time or seasonal employees, because for employers that have a large number of those types of employees, it was probably very difficult, if not impossible, to qualify for the transition rule number 2, I'll say, that we had just previously talked about.
So hopefully, for those of you who are out there that do operate on a non-calendar year basis, between these 3 transition rules, you will be able to defer the first day of your pay or play penalty effective date until the first day of your 2015 plan year. So that's really a summary of all the transition relief that we want to talk about right now. We will be mentioning some other transition rules in the rest of our presentation today. But now we're going to talk about that favorite topic of many of you, and that is the measurement period. You may recall that we spent a lot of time in the past year talking about what we call the look-back measurement period and the stability period. Well, one of the things that the final regulations do is they make it clear that that's not the only way to get your arms around figuring out who is a full-time employee if you're a large employer and need to offer folks health coverage. What the final regulations say is that there's really 2 methods. One is a monthly measurement period, and the other is that look-back measurement period with a stability period. So first, let's talk about that monthly measurement period. What you could do, if you wanted, would be to say, we're going to look at this every month. So if I am an employee that had at least 130 hours for the month, I have to be offered health coverage for that month in order to avoid the pay or play penalty. Now, you might say to yourself, Mary, why 130? And that's because the IRS has said that it's 4 weeks times 30 hours a week in a month, plus every month has a magical 1/3 of a week in it. And so that's why we use that period. Now, for most of you, I would think you would not be interested in this measurement period, because that means you have to make a decision every month whether the person would be eligible or not, unless, of course, you decide to be more generous and provide coverage to everyone. A second method, and this is the one that we've kind of always thought was the key method, and I suspect most of you will offer this method, is called the look-back measurement period, stability period method. And here, it's not doing a month-to-month, looking at the month and then retrospectively making sure people had coverage for the month. Rather, what we're doing is we're saying, are employees full-time during this look-back period? And if they are, then we have to give them coverage for a future stability period. So we're looking back to determine our obligation to offer coverage for a future period. Now, the other thing that's important to always keep in mind if you use the measurement period and stability period rules is that there are 2 sets of measurement periods and stability periods. One is for new hires and only certain new hires, and the second is for all ongoing employees. And of course, the new hire measurement period and stability period is only conducted one time, when the person becomes a new employee. On the other hand, the measurement period, stability period for all ongoing employees, as if you've heard me speak before, I refer to it as the Hotel California. You can check out any time you want, but you can never leave, and that's because you're doing it again and again and again. Okay, so let's talk about how this flushes out for new hires. The first thing to keep in mind is that if I am a full-time employee, you can't subject me to a look-back measurement period when I'm hired. You have to rather offer me coverage by no later than the first day of the month following the employee's first 3 months of employment. And I should mention a couple things here about full-time employees. First of all, we count your hours based upon the hours you work for all commonly owned employers. So let's say I have 2 commonly owned businesses that are really a single employer under what we call the control group rules. I have an employee that works 20 hours for one and 20 hours for the other. We have to aggregate those hours in figuring out if the person's full-time. The other thing I should mention is that the proposed regulations provided a exception to this rule for short-term assignments and said that employers weren't going to really have to worry about offering coverage to folks that, let's say, you were going to hire full-time, but it was only going to be maybe for 4 or 5 months. There was going to be some relief from that in 2014. Well, now the pay or play has been delayed by a year, and so the IRS came out in these regs and said no relief or exceptions for employees who work on short-term assignments. So if you offer coverage, if you hire somebody full-time, let's say they're replacing or substituting maybe for an employee that you know is going to be off on a medical leave, and you say you're hired for 4 or 5 months and you're working 35 hours a week, you need to offer that person coverage after they've worked for you for 3 months. Now, Tripp, I know that just after these regs came out last week, we also got new regs on the 90-day waiting period rule. And how in the world does the 90-day waiting period rule coordinate with this rule about offering coverage by the first of the month following 3 months?
That's correct, Mary. You know what they say, when it rains it pours, or if you're this far north, when it snows it's a blizzard.
Oh.
So we did get the final regulations on the 90-day waiting period, and from my past experience of giving these speeches or presentations is when I mentioned that under the pay or play regs, coverage must be offered to these new full-time employees no later than the first day of the month following the employee's first 3 months of employment, I usually have a few hands that shoot up with questions and say, well, I thought we had to offer coverage. We couldn't impose a waiting period longer than 90 days. And that's absolutely correct. Now, in the final regulations on the 90-day waiting period rules, which were just released last week, clarified that using a concept called an orientation period, we can actually coordinate these rules. And I don't know, maybe the orientation period is a discussion for a different day, but the final regulations did say on the 90-day waiting period, did give a mechanism of which we may coordinate these rules going forward.
Yeah, I think what Tripp's alluding to here is that this new orientation period is absolutely nuts. You can have an orientation period of 1 month minus 1 day and have that precede the 90-day waiting period with coverage effective on the 91st day. But we think that because that orientation period can be up to that length of time, what it's really trying to say here is if you've got your heart set on a first of the month after 90 days, this is a way for you to accomplish that. So kind of crazy, but that's the new release that was just announced by the IRS last week. Okay, so for new hires, as I said, we need to offer them coverage by the first of the month within after 3 months in order to avoid the pay or play. But it's not the case for newly hired variable hours, seasonal, and part-time employees. For these 3 categories, we can subject them to a measurement period first. So who are these folks? Well, variable hours employees are employees that you can't determine on their start date whether they are reasonably expected to work an average of 30 or more hours a week. That's a carryover from the old regulations. What's added by the new regulations is some factors to help you make this determination, such as who is this person replacing, a full-timer or a part-timer or a variable hours person? How many hours do employees work in the same or comparable positions? And was this job advertised or communicated as a full-time or variable hours? In other words, if you want to treat somebody like their variable hours, the IRS is going to be looking for you to make that determination on a reasonable good faith basis, and you may actually need to prove that that's a reasonable position for you to take. Seasonal employees, this is something that was suggested in the proposed regulations, and they've now firmed that up, that seasonal employees are folks who work in a position where the customary annual employment period is 6 months or less, and they customarily start working at the same time each year. Tripp, what about this definition? It's not confined to, for example, agriculture or retail during holidays? It's not confined to those categories?
It's not. And I think here's the important distinction to realize is there is, under these rules, there is a difference between a seasonal employee and a seasonal worker. A seasonal worker comes into play when you're trying to determine if you're right on that borderline of being a large employer, if possibly I can escape that being a large employer because I hire a certain amount of seasonal workers. That's when you use the seasonal worker definition, and seasonal workers are confined to certain industries like agricultural industries or retail workers during the holiday season. Season employees, when it applies to when you can use an initial measurement period, is defined as you see on the slide right here, and there's no other confinements other than what you see up here.
Okay, which is good news. And then part-timers, this was specifically added by the final regs as just really to clarify, and that is if you reasonably expect somebody on their start date is going to average less than 30 hours a week, you can certainly subject them to a initial measurement period. So for these three categories of employees, you can, you're not required to, but you can subject them to a measurement period of between 3 and 12 months. And during that time, they have to average 30 or more hours a week. And if they do, then you have to offer them coverage to avoid the pay or play. If they don't, you do not. So here's an example, and this is very comparable, folks, to examples that we gave in the past year under the proposed regulations. So I'm a seasonal employee. Let's say I'm a summer help person. I'm hired on May 14. My initial measurement period is going to start on the first day of the following month, June 1. Now, I should note that you could start it on their date of hire, you could start it on the first day of the first payroll period on or after their date of hire, or you could start it on the first of the month. We kind of like the first of the month approach because that way you're capturing all of your hires during May and testing them all beginning on June 1. So you're only doing 12 of these a year, not 365. And then followed by that, there's going to be an administrative period. In this example, we've got it as 1 month, and that's because it can't extend past the last day of the calendar month beginning on or after that person's anniversary date. And then finally, if they do average the hours, you have to offer them coverage during the stability period beginning on July 1, in this example, 2015, going for 12 months because the stability period has to be at least 6 months long and it has to be as long as the measurement period. So here, if we use a 1-year measurement period, we have to use a 1-year stability period. Tripp, how do these rules coordinate back with those new waiting period rules that you just mentioned?
Well, this is really an exception to the 90-day waiting period rule. So if you are reasonably applying these rules, then you are not required to offer coverage within 90 days by the 91st day of an employee's start date. So again, these rules would coordinate with the 90-day waiting period rules.
Okay, awesome, awesome. Okay, so that's the first look-back measurement period and stability period. The second one, as I mentioned, is for all ongoing employees. And when I say all, I mean all. So it's not just variable hours, seasonal, and part-time. It's also full-time. So I can subject folks to a measurement period every year or every measurement period in order to qualify for coverage during the immediately following stability period. So once again, here's an example. Again, reminiscent of examples I've given you in the previous year. So here we've got an employer that operates its plan on a calendar year basis, and their first standard measurement period is going to be November 1, 2013. That's right, it's already started, through October 31 of 2014. But again, it doesn't have to start on the first day of a month. You might want to say, for example, it starts on the first day of a payroll period. And there's some additional flexibility built into the regulations, but those are the two most common starting dates. And then the administrative period in this example is going to be the months of November and December. And here the only rule is that that administrative period can't exceed 90 days. So it can't be 3 full calendar months typically, because you're usually going to have 1 or more calendar months that are 31 days. And then the stability period has to, again, be at least 6 months long and as long as the measurement period. So once again here, because our measurement period is a full 12 months, then our stability period also has to be 12 months. Now again, if you are subject to the pay or play as an employer with 100 or more full-time employees, the first stability period for you is going to begin on the first day of your 2015 plan year. So it might not be January 1, 2015. It might be April 1, 2015 or something like that. But the key thing is to figure out what that's going to be, that first stability period, and then back up from there. What I should also mention is that most of my clients seem to gravitate toward the 12-month measurement period and 12-month stability period simply because for ongoing employees that can then coordinate with the employer's plan year, obviously, which is also 12 months. Now, there's also a transition rule that employers can use just for 2015. And for 2015, if there's a stability period that's going to begin in that year, the look-back measurement period can be less than 12 months long, even though the measurement period, even though the stability period is 12 months long. The requirements are that the measurement period begins by July 1 of this year. It's at least 6 months long, might be 7 or 8, and it ends no earlier than 90 days before the start of the 2015 plan year. So here's an example. In the previous illustration that we just gave you, the first measurement period was going to run from November 1, 2013 to October 31, 2014. Under this transition relief, you could instead have it start on May 1, 2014 and end on the same date, October 31, 2014. Tripp, why would an employer be interested in this relief for that first year?
Well, if nothing else, it gives employers additional time to come into compliance with all these regulations. They can delay when they have to start their measurement period. I think there's another reason that you would want to consider this, and for some employers it may present a potential planning opportunity. So, for example, if I'm picking the May 1, 2014 to 10/31/2014, maybe that's an off-peak season for me, and my employees aren't working as many hours. So therefore, I'm reducing the amount of my full-time employees in my first stability period.
Yeah, so like, for example, if I'm a snowplower, this could be a good deal.
I hope so.
Okay. You know, if you can't have fun doing employee benefits, what can you do? I don't know. Okay, so now we go on to our next slide, also regarding the measurement period and stability period. Something I want to emphasize here, and that is the feds recognize that one size may not fit all. And what I mean by that is the final regulations do specifically permit you to slice and dice this. So you may want to, for example, have a different measurement period and stability period for different groups of employees, either the length or maybe the starting and ending dates. Maybe you pay hourly employees weekly and salaried employees biweekly or monthly. So that would be one logical reason why you might want to split things up. Here's the little rub, though. What the IRS said in the final regs is that you can definitely change this up for groups such as salaried versus hourly, employees working in different states, union versus non-union employees, union versus union. So if you've got multiple collective bargaining units, you could separate it by unit, or large employer member by member. What I mean by that is if you're in a group of commonly owned businesses, each with their own separate EIN, you might run this on a different measurement period and stability period for those different groups on an employer-by-employer basis. So those are all really positive, but other divisions apparently are not. So let's say that I'm an employer that has two classes of hourly workers. Maybe one is like a production hourly worker and the other is non-union, and the other is a clerical hourly worker, non-union. Could I subject them to different measurement periods and waiting periods? It doesn't appear that that is specifically permitted by these regulations. So that may permit a bit of a quandary for some of you. Okay, some other issues that are, I don't know if I want to say clarified, but elaborated on in the regulations. You're probably going to feel more frustrated than ever when we go through some of these rules, but a little bit of clarification. What if I am variable hours, seasonal, or part-time, and I transfer to a full-time position? Well, if I transfer to a full-time position during my initial measurement period, that first year after I'm hired, then you have to offer me health coverage by the first day of the 4th month after I transfer, or as of my first stability period if earlier. in order to avoid the pay or play penalty. On the other hand, what if I transfer from a variable hours seasonal or part-time position to a full-time position later, after I've been working for you for 3 or 4 years? In that case, because it's beyond my initial measurement period, you can make that person wait until they've actually completed a look-back measurement period when they've averaged 30 or more hours a week. Now, it doesn't preclude you from being more generous and offering them coverage earlier, but if you wanted to wait, you could. What about the other way around? What if I go from full-time to less than 30 hours per week during a stability period? Well, the rule in the final regs generally is unchanged from the proposed regs, and that is, in this situation, I really generally can't change their coverage, their eligibility for coverage, until the first stability period, as of which they aren't eligible based on the look-back period. So if you're one of those employers out there that is going to say, you know what, I don't really want to track any of this, I'm not going to have a look-back period and a measurement period, I'm just going to give everybody coverage, but I only want to give it to my full-timers, and somebody transfers from full-time to part-time, you've got to come up with a way, I think, to track their hours in order to cut their coverage off. So that's going to be a challenge for you. Now, here is another rule that is absolutely nutty, and I'm going to really rely on Tripp here to help me explain it, and that is, if I am a full-time employee, I was hired and I was initially offered coverage in my first 3 months of work, and later on I switched to from a full-time position to a less than full-time position, could I cut off my coverage early? And the answer under the final regs is yes. And the way that you would do it is you would convert that person at the time of transfer to a monthly measurement period, and then you would track their hours basically for 3 months to establish that they have in fact reduced their hours. And by doing so, you can terminate their coverage before the end of that stability period. So it gives you a way to terminate their coverage instead of having to wait. Tripp, did they give any reasoning for this in the final regs?
Yes. The examples that were given were really to facilitate your employees that are maybe in a phased retirement. So they're reducing the amount of hours they work on a weekly basis because they are going to retire at some point in the future, and that slowly, those hours slowly then become reduced. Another example may be for employees that are caring for family members, either sick or injured family members that are not protected under FMLA.
Yep. So kind of I would say it's complicated, but it is a tool.
It is complicated.
Okay. Moving on. One of the challenges for all of this is tracking hours. And I would say that the proposed regs and the final regs are not all too different on the basic rule. And that is, we're looking at hours that somebody works and is paid, some hours that they're paid but they don't work, like they take vacation, and of course unpaid leave due to FMLA, USERRA, which is the military leave law, or jury duty. Tripp, how does this work with FMLA and USERRA and jury duty?
Well, the individuals that are on the webinar that are representing educational organizations are probably pretty familiar with these rules, because it's the same rules that apply to special periods of unemployment at educational organizations of over 4 weeks off. But there's really 2 methods to calculate. You can't just give people in these situations goose eggs for as far as how many hours they work in that week. You can either take you can figure out their average by excluding these weeks, or you take their average excluding these weeks and impute them to these special leave periods.
Do those get you to a different place, Tripp?
You know, when the proposed regulations were issued, it didn't indicate that it was, but I was sitting at my desk and it was an epiphany after I worked through a few examples and discovered I can't make these result in 2 different outcomes. And thankfully, for my own sanity, the final regulations did specify that these are 2 methods to arrive at the same result.
Yeah, so either one gets you the same place. Okay, then what about salaried folks? Well, salaried folks, mandatingly, you have to give them the same, you have to track their actual hours. And of course, many of you don't do that for salaried folks But that's one method. And if you don't track their actual hours, you have to either use an equivalency method of 8 hours for each day that they're credited with an hour, or 40 hours for each week that they're credited with 1 hour, which may or may not be an acceptable method depending on how you schedule your salaried employees. You can use different methods for different reasonable categories of employees. So I think that is, and there's not the same distinction as there is for measurement periods and stability periods. It appears that you've got a little bit more flexibility here, which could be a useful tool. Now, one of the things that the final regs did was they called out certain categories of employees. One of the things they did was they said, if you've got a volunteer, and they're what we call a bona fide volunteer, you will not have to count their hours of service. They said that they were doing this really because of volunteer firefighters, but it could be a person that not only works for a governmental entity, but also a tax-exempt entity. And as long as you really confine what you pay them to either reimbursing their expenses or giving them some type of allowance for expenses, and any other reasonable benefits and nominal fees that similar entities might pay to volunteers, you can carve these folks out for purposes of the pay or play. The other thing that you can do is for student employees, if you can exclude their hours that are worked in a federal work-study program or a similar program, for example, of a state or other governmental entity. But other hours that the student works are counted. Now, this particular exception, Tripp, seems to be focused on, for example, hours that a student might work for an educational institution, like a college or university. What about, for example, a student that is interning with a private sector employer?
Well, it really comes down to whether the student is working in an unpaid position or a paid position. So, and this is actually a fairly straightforward and simple rule. If the student intern is a paid position, then you are counting those hours. If it's an unpaid position, you're not counting those hours.
Right. But a student, for example, might be able to be classified as a seasonal employee if they just work in the summer, for example?
Absolutely. So if you have a paid student intern that's just working in the summer, that seems to be a position that lasts for 6 months or less and occurs during the same point of each year. So absolutely, a student intern could be a seasonal employee.
Okay, the other new piece of guidance that was provided in the final regs is concerning adjunct faculty members. We've had a lot of our higher ed clients wringing their hands about this one. And at least for 2015, unclear if this is going to be a safe harbor beyond 2015, but for 2015, what the employer can do with an adjunct is to say, we're going to impute hours based on the following formula: 2¼ hours for each credit hour that they actually teach for the week, plus an hour of service for their additional work outside of the classroom that is performed regarding required duties, like required office hours and faculty meetings. Tripp, does an educational organization have to use this safe harbor?
No, this is a safe harbor, so it is an optional provision. The rule is that any reasonable method may be used, but keep in mind, reasonable minds may disagree.
Right, right. So, okay. Another category that was added by the final regs is a little bit more guidance on on-call employees. And I know there are some employers on the call today that have on-call employees. Again, on-call employees, you can use any reasonable method to credit their hours, but what the regs say is when you're applying that reasonable method, you really need to credit them with any hour for which they are paid, any hour for which they are required to be on the employer's premises, and any hour for which the employee's activities are significantly limited because of being on call. And, you know, I think that is in the eye of the beholder, Tripp. I think that's going to be a hard one to apply, but this is some new guidance that we've received on on-call employees. Another modification in the final regulations is regarding rehires. If I am rehired and I'm absent from work for at least, what is this, right, well, they'll be treated as a new employee only if they're absent from work for 13 weeks or more. So if I'm absent from work for 10 weeks and I come back, you can't treat me as a new hire, but if I'm gone for 14 weeks, you can. That's different than the old regs, which said the break was 26 weeks, and in fact, the final regs retain the 26-week threshold for educational organizations. And there is also another rule that was in the proposed regs that continues in the final regs that's optional. And under this rule, if the person worked for you and then they were gone for at least 4 weeks, and the period they were gone exceeded the length of their prior employment, that's called the rule of scarcity, and you can treat them as a new hire under that scenario as well. Tripp, some folks today on the call might be thinking, well, why in the world is this even important?
There's a few reasons, and we'll give you one example is now that we have the clarification on what a seasonal employee is, now we know that for seasonal employees, we can treat them as a new employee every time they come back to work for the new season. So we don't need to try and keep track of their hours when they're not working and then when they are working to try and determine if they, on an ongoing basis, are a full-time employee or not.
Yep. Okay, now we're going to turn to another topic, and that is temporary staffing agencies. And, you know, these are called all kinds of different things, folks. Temporary staffing agency is just one name, but they might be a leasing organization, a PEO, whatever, but we're going to call them all temporary staffing agencies for purposes of our comments now. The final regulations have a really useful tool in the regs to help employers and temporary staffing agencies where there are full-time employees working through that temporary staffing agency for the employer. Specifically, here's the rub, guys, and that is if I, the recipient or client employer, have the right to direct and control employees, so in other words, I have the right, even if I maybe don't do so, but if I have the right to direct and control those folks that I hire through the temporary staffing agency, they are probably going to be considered my common law employee for purposes of the pay or play. In other words, they're not considered the temporary staffing agency's employees, they're considered your employees. It may be possible to change that relationship and cause the employees to be the common law employees of the temporary staffing agency, but that's going to really require, you know, removal of that right to direct and control the employees, which I think is going to be very challenging. So that's the first thing for you to remember is, I hire employees through a temp agency. Are they my employees for purposes of pay or play? Probably. But what the final regulations say is, if the temporary staffing agency would offer these employees health coverage, and the offer associated with the offer, if somebody actually elects the coverage and enrolls, I charge the client employer a higher fee, then it's considered to be an offer of coverage by the employer, the client employer, for purposes of avoiding the pay or play. So what does this mean? What this means is, if you haven't done it already, you should take an inventory of, do we have any leased employees, temp employees? Who is that through? Does the temp agency offer a health plan? What does the administration agreement say? Does it require me to pay a higher fee if the person is offered health coverage? Now, I should mention that this will get me out from under the $2,000 penalty if I am a large employer, but not necessarily the $3,000 penalty if the coverage that the temp agency offers isn't affordable or isn't of minimum value, and I decline that coverage and I go to the exchange and enroll there and obtain a premium credit. So it's something to be aware of, but I do believe that it is a useful tool for you as you work through the pay or play. So what is still missing? Well, I think one thing that we're still looking for, Tripp, is definitive guidance on how to track hours relative to what I call non-traditional employees.
Exactly. So the adjunct rule that we just talked about, we know that we can use that at least through 2015, but we are looking for definitive guidance on that. Another example would be for the individuals who have commissioned salespeople. Tracking those hours still could present lots of difficulties without any additional guidance. Again, the rule at this point is you have to use any reasonable method.
So probably have to include their hours while they're driving to their sales call, but maybe not thinking about it in the shower?
Correct.
Okay, gotcha. Okay. And another area where we're looking for guidance is the whole temporary staffing agency employees issue, and really we're hoping that they do give us a little bit more definitive guidance to help us determine, is that person the common law employee of the temp agency or the common law employee of the client employer? Another area that I think is often overlooked is we're all so paranoid about the pay-or-play penalty because it's could be potentially a big dollar figure. But as many of you know, there is also an extremely awful penalty under healthcare reform that is sometimes referred to as the IRS excise tax. It's under 4980D of the Internal Revenue Code. And what this penalty says is, if you don't comply with certain aspects of healthcare reform, like the 90-day waiting period, or maybe the requirement to offer coverage to dependent children to age 26, or one of these other requirements, you're looking at a penalty of, it appears, up to $100 a day, not clear if it is up to or $100 a day, for each what they call affected individual where your plan is in violation. Now, what in the world does affected individual mean? Gee, Tripp, does it mean every single participant in the plan, do you think?
It could, but again, there's a question.
Right, or it could mean every person adversely affected by the employer's violation. We just don't know, and that's something that we're waiting for guidance on. Another area that we're really waiting for guidance on, and this is one that I know Tripp has spent quite a bit of time on, is employer reporting with respect to not only the pay or play, but the individual mandate penalty as well. And I know, Tripp, that they indicated in the preamble or the press release that these associated with the pay or play regs, that these would be due out shortly. What can we expect to find with those regs?
Well, I think we need to be looking for two things, and that's first the final regulations on these reporting responsibilities, and then next the IRS has to issue the forms on which you're actually going to do the reporting. I think both will answer some good questions. Remember, the reporting requirements really come in two parts, and that's reporting for the pay or play penalty, which we've just talked about today, and then reporting for the individual mandate penalty, which is the mandate that most individuals in the United States carry health insurance. So these reporting requirements appear that they're going to be similar to the mechanism of a Form W-2 reporting requirement, and by that I mean there's going to be a reporting requirement that goes to not only the IRS but also to the employee. I think at this point the good thing that you should take away from this is the earliest required reporting is not going to happen until January through March of 2016, of which you'll be reporting for the 2015 plan year, or calendar year, I'm sorry.
So we've got a little bit of time on that, but that's something to really look out for. Another thing that many of you have asked us about is healthcare reform added non-discrimination regulations, rules rather, with respect to fully insured non-grandfathered plans. And the IRS, after the law was enacted, came out and said, you know what, we're not even going to enforce these new requirements until after we issue regulations. And everything that we have seen from the IRS, it appears that these regulations are really not in immediate sight or on the horizon. So I think that at this point, I would say 2015, these rules would apply at the earliest, and it may even be 2016 or later. Okay, so what should your next steps be, your takeaways on the pay or play? I think the first thing you need to do is figure out who you are. Are you small? Are you mid-size? Are you large? If you're small, you are going to have to collect some data to evidence that. If you're mid-size or large, you're going to want to figure out what is your effective date for the pay or play. Are you on a non-calendar year plan year, and the applicability of the transition rules. So you're going to want to take a look at who you are and your size. The next, I think, steps that you're going to want to look at is, are you offering coverage to at least 95%, or at least for the first year, 70% of your full-time employees, and have you correctly identified who your full-time employees are? Maybe you forgot all about these temporary staffing agency employees, and you need to take a new look at this. And remember, full-time means 30 or more hours a week. I think the next question that you have to decide is, are you going to make sure that your coverage is affordable, and what safe harbor are you going to use? Tripp, do you think this is an all or nothing thing? Do I have to make coverage affordable for all my employees?
No, absolutely not. You just have to realize that if you don't, there is the potential that you may have to pay the $3,000 penalty for any of those employees that go to the exchange. Now, you may be in a position that you're going to say, well, geez, only 90% of my full-time employees I'm going to offer affordable coverage to, because I'm either willing to accept that risk of paying that $3,000 penalty, or I'm fairly confident that these employees aren't going to go to the exchange and get a premium tax credit because they're eligible and entitled to Medicaid, Medicare, or they're enrolled in their employer spouse's plan.
Yeah. So it may mean that it costs you less to be a little vulnerable on the penalty with respect to a portion of your employees than making coverage affordable for every single last one of them. And then in terms of whether your coverage meets the minimum value test, that's really a question that I think you can ask pretty easily to your insurance agent or broker or consultant, and they can work with your insurance carrier or third-party administrator to help you make that determination, but that's usually something that is pretty straightforward. Next steps, you're going to want to look at, are you going to adopt a look-back measurement period and a stability period? For some of you, you may have already said, I'm going to do this, and I've already kind of set this up. You're going to maybe want to take a new look at that and make sure that what you've done is in compliance with the final regs. And when we look at establishing the look-back measurement period and stability period, are we going to do it just for those new hires who are variable hours, part-time, or seasonal, or are we going to do this for only from our ongoing employees, or one of the, or vice versa? You also want to look at that transition rule for the first year. Are you going to use that to go just a 6-month look-back measurement period for year 1? And also, are you going to do different rules for different groups of employees? And are the groups that you want to split up going to be permissible under the final reg? So those are all some questions that you need to ask yourself. Then I think the next thing you need to ask yourself is, have I set up a system to capture hours? You know, hourly workers may be pretty straightforward. Salaried employees, you have to figure out how you're going to do that. And then you have to look at whether you have any special categories of hours and how you're going to track the hours of those workers as well, and what kind of reasonable method that you're going to use. And I think really the last step in the equation is you're going to need to look at modifying your health plan and your SPD. You're going to have to look at who is an eligible employee. Are you going to go down to 30 hours or not? And are you going to have any measurement period or stability period? It's really unclear. They didn't specify this in the regs, but do you have to spell this all out in your plan and SPD if that's what you're going to do? They didn't say you had to, but yet under ERISA, we do have an obligation to have an SPD that adequately communicates our eligibility rules to participants. So it seems to me that if you're going to hinge and condition eligibility based on a measurement period and a stability period, then you're probably going to need to define that somehow in your plan and SPD. And then, of course, you're going to want to take a look at your dependent child definition and get on track to getting into compliance by 2016. And then finally, as Tripp mentioned, we're going to have to keep on the lookout for the IRS reporting requirements, which are not only to the IRS, but also to the employees. So hey, I want to really thank all of you for your participation in our call today, and Tripp thanks you as well. Again, want to remind you that we are going to be sending out an email after the end of our presentation today with a copy of the slides and a link to our website with information about how to view the recording of today's presentation. And of course, if you have questions, you can see our contact information, and as well, feel free to call or email any attorney in the Employee Benefits Practice Group that you may regularly work with. Thanks a lot, and have a great day.